Good afternoon, everyone. Welcome to Venable and our program today entitled Key Trademark and Copyright Rules for Nonprofits to Follow and Break. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. This program today is part of the monthly series of programming that our nonprofit group has put on for the last 3+ years now on a variety of different nonprofit legal topics, all of the various legal issues that we deal with our nonprofit clients on a daily basis. And we host these monthly programs here in our D.C. office. For those of you who are in the D.C. area, always welcome to attend and join us for lunch. And for those of you on the webinar today, we have over 200 people registered online from across the country participating by webinar. We always do these from 12:30 to 2 o'clock Eastern Time once a month. We have, and I should also note that all of the programs that we do are recorded and are available for your viewing pleasure on our YouTube channel. We have a nonprofit YouTube channel. You'll see the link to that on the last slide of today's PowerPoint presentation. So feel free to go back and take a look at all of the programs we've done over the last 3 years. There's a lot of really interesting, valuable material there, the recorded webinars along with the PowerPoint slides and all of the related handout materials. Speaking of handout materials, those of you here in D.C. have a book in front of you that has a printed copy of today's PowerPoint slides, bios for our speakers, and some related articles written by Venable attorneys on various nonprofit trademark and copyright related issues. Those of you on the webinar today, I got an email containing a copy of the PowerPoint slides, and tomorrow all of you will get an email that contains a link to the recording of today's program, as well as the related handout materials and PowerPoint slides. Feel free to forward that on to colleagues and others who you think may benefit from that. As some of you know, beginning this month, beginning with this program, the programs that we put on every month, for those of you in the trade and professional association community who may be certified association executives, the certification program run by the American Society of Association Executives, ASAE, Venable is now a CAE approved provider, so you can get CAE credit, continuing education credit for these programs. Preview of our upcoming programs. We have 2 scheduled so far. In August, our program is entitled Privacy and Data Security for Your Nonprofit, Understanding Your Legal Obligations and Insuring Against Risk. And on September 16th, our program is entitled What's Ahead for 2015, Preparing Your Nonprofit's Group Health Plan for the Employer Mandate. We hope you can join us for those programs. For today's program, we are encouraging you to ask questions throughout the program. For those of you in the room, just raise your hand, and we have some folks with handheld microphones in the back of the room who will come over to you. Just wait until the mic gets to you so that those of you in the webinar can hear the questions posed from the room. Those of you on the webinar should pose your questions using the chat feature on the webinar software, and I'll pose those questions to our speakers at the appropriate times. But we want this program to be very interactive. This is an area that's, believe it or not, one of my absolute favorite topics in nonprofit law. Trademarks and copyrights are an area that it's an area that's very complex, very counterintuitive, very interesting applications in the nonprofit space. Some areas of law, like for instance employment law, don't have a lot of unique applications in the nonprofit area, but trademarks and copyrights and other intellectual property law certainly does, and we're going to focus on some of that here today. We're very fortunate to have 2 of my partners here today with whom I've worked very closely for virtually my entire time at Venable. To my immediate right is Andrew Price. Andrew is a partner in our trademark practice. Andrew is the lead trademark attorney for most of our firm's nonprofit organization clients. Andrew works with hundreds of clients every year on a variety of trademark-related issues. He's an absolutely first-rate lawyer, has a terrific team of attorneys that work with him, knows trademark law inside and out, but also has a really unique appreciation for how trademark law applies in a nonprofit context. Something I think you're going to find very valuable here today. And there is a prior recorded webinar that Andrew did with AJ Zatola, I think, with one of our colleagues a while back on trademark and copyright issues, that if you're interested, you can go back and listen to that. Today's program is going to focus on some more interesting kind of advanced topics in the trademark and copyright area. But of course, there's a lot of basics that are very important and that are not kind of widely known by a lot of our registrants today. So it's going to be a combination of some of those kind of newer, hot, interesting topics and some trademark and copyright basics as well. To Andrew's right is Justin Pierce. Justin is a partner at Venable. Justin and I worked together in the early years when I was at Venable about 15 years ago, and then he went in-house for, 7 years? 7 years at then Sony Ericsson, now Sony Mobile, as an in-house intellectual property lawyer. Justin covers a whole variety of intellectual property issues, copyrights, trademarks, and other IP. He's going to focus primarily on copyright issues today. And then we were very fortunate when Justin came back and joined Venable about, 2 years ago or so, and we've had the good fortune to be able to work with Justin again and have him work with a number of our nonprofit clients. Andrew and Justin have worked very closely together, including the 7 years that Justin was in-house, and so they have a terrific working relationship, and I think you're going to enjoy the benefits of that here today. With that, their full bios are in the handout materials. If you want to read more about them, please do. So with that, remember to keep your questions flowing, and I'm going to turn it over to Andrew to get us started. Andrew?
Jeff, thank you very much, and thank you to everyone who has joined in person and by webinar and may watch this or listen to this in the future on the recorded webinar version. So let me start by asking a question to everyone in the room. How many lawyers do we have in the room today? Okay, so at least half, maybe 60%. How many people do we have in the room who have some background in trademarks, instructing outside counsel, making decisions within the organization? So not many, maybe 10%. And so with that background, we're going to be talking about some, I think, cutting-edge issues in trademark law generally, and very cutting edge in the nonprofit context. And so what we'll try to do is juxtapose those kind of novel cutting-edge issues in trademarks and copyrights with some of the basics as we go. And we really encourage you to ask questions, because trademark law and copyright are very fact-specific areas of the law. And so I think we'll all learn more if we can apply the things we're talking about in a factual circumstance. So we've got a couple of microphones in the room, and so just raise your hand if you have a question, and we'll bring you a microphone. So we've got two items on the agenda, as Jeff previewed. First, trademarks, and second, copyright. We'll have a little bit more time spent on trademarks, which is going to focus on how to follow and break the so-called acid test, and we'll tell you the 4 parts of that acid test. But we have kind of a working theory and have written an article on it, and I think it will be a good topic to get discussion going today. But essentially, we believe that brands, counterintuitively, we believe that brands need not always be used as adjectives and in a consistent manner, and that's really against the historical thinking about what to do in the trademark world. So we believe that if you have a strong brand, that it can be flexible and fluid, or as we're going to call it, living. Justin, will you introduce the copyright side?
Sure. So in keeping with our theme today of rules in terms of rules to follow and break, on the copyright side, we're going to address the issue of breaking reliance on the old automatic creation rule. Also, in keeping with Andrew's questions to the audience, a number of you raised your hands as lawyers. Smaller amount raised your hands as trademark attorneys. How many people here have dealt with copyright issues in the past? Thanks. So with that, the main issue I want to touch today, at least introduce with this particular topic, thanks, is the fact that the old rule and old reliance is that when it comes to copyrights, people get copyrights without even having to take the step to register them. As soon as you create some type of content, some type of work, it's copyrighted. That's still true, but there's a lot more you need to do. So we'll go further and get into it in more detail as we talk through the topics.
Okay, so jumping right in here to trademarks, follow and break the acid test. So what is the acid test? Raise your hand if you've heard of the acid test. Anybody? Okay, so a couple people, maybe 2, 3 people out of the room have even heard of this test. So this test, a lot of different people will talk about it on the INTA website. If you've heard of the International Trademark Association, or INTA, they are the leading organized nonprofit body that kind of gets people together and provides information on trademarks. And so they have some very good basics materials regarding trademarks, and they have a piece that intrigued me because I've heard about the acid test, of course, my whole career, And Justin and I got focused on this at the end of 2013, actually. So we took a look at these materials and started giving them some thought in the context of how organizations, including nonprofits, are starting to trend in a little bit of a different way. So the test is that you're supposed to use trademarks only as adjectives, not as nouns or verbs. Only use them in a consistent manner. Never change your trademark. And use an identification symbol like a TM or a circle R with the brand to indicate whether it's registered, and just as a matter of basics. So the TM or SM is a symbol that indicates that you have a claim or making a claim to trademark rights, but that you do not yet own a registration. The circle R symbol is an indication to the public that you do own a registration, and so that's the third part of the acid test, to give that indication to the public. The fourth part is to use the brand in a distinctive or attention-getting manner. And so with that test in mind, I thought I'd give a brief summary here of the rules to break and follow and how we view things today. So we believe you can break the first two parts of that test and that you should follow the second two parts. So just to sum up, in terms of rules to break, we think you can break the rule that trademarks need to be used as adjectives. We think you can use them as nouns and verbs in some cases, especially for strong brands. And we think that you can also break the rule of using brands in a consistent manner, and we've got some reasons why we think this is the case, but those are the rules to break. The rules to follow, of course, use the TM or SM symbol. I should also mention that the TM and SM are really mean about the same thing. SM technically means it's a service mark, which is like for a nonprofit. Typically you're providing services. A TM is for goods, like if you have a can of soda, that's a TM technically speaking, but really the TM is the catch-all, and you shouldn't lose too much sleep over TM versus SM. And so we think you should use the appropriate symbol, whether it's registered or not, and we of course think that you should use brands in an attention-getting, distinctive manner. But today we think, again, overall that strong brands can be flexible and fluid, or as we call them, living. So let's start on this first point of the old rule using trademarks as adjectives. So that was the rule. And Justin, do you want to get us into this concept of genericide and talk about that?
Absolutely. When we talk genericide, it's a term that sounds really serious. It simply is this: the concept of taking something that's distinctive or a brand and has an inherent meaning in and of itself and turning it into more of a common word. The example you see here in the slide is probably one of the most famous ones, with the company Xerox. It was sort of a victim of its own success, so much so that in popular lexicon, or in terms of how people spoke, Xerox became synonymous with copying. So they kind of won the marketing battle. Unfortunately, because of that, it lost distinctiveness, and they were really in various situations looking at the possibility of people using Xeroxing for copying, and the ability then of not being able to deny other third parties or competitors or anyone else from just saying that they're Xeroxing. Hence, then you destroy your ability to really be distinctive as a brand. And so genericide, quite simply, is allowing your brand to become used really as a substitute action where there's no distinctiveness, which in essence kills the brand, hence genericide.
So if genericide occurs, in a worst-case scenario, you lose your trademark rights, and that is obviously something no one wants to happen and everyone wants to avoid. So people hear genericide, and they hear about this old rule of always using brand as an adjective. And just as an example, by the way, it would be Venable Law Firm. So the law firm is, in that context, used as a noun, and you're really using Venable, which originally is a noun, of course, but you're using it in a manner that is really, truly functioning as an adjective. So everyone has this fear of loss of rights, and it's a mantra that every trademark lawyer repeats to their clients. But the times are different now, and of course it's been very interesting to work with Justin for 7 years, literally on almost a daily basis, serving not only nonprofit clients but also clients in the mobile industry. And of course, as most people in this room are aware, there are really changing times in the last 5 years, 10 years, where consumer sophistication is different than it used to be, where expectations are different, and that, I think, creates the context for some flexibility when it comes to the acid test. Justin, what are your thoughts on the times changing?
Yeah, I totally agree. I think all of us here in this room probably have a mobile device or two on you, and what that really means is that there's a lot shorter attention span, and there's a lot more demand in terms of being responsive, whether it's in your day-to-day lives for routine things. But if you think about it, people's attention span has shortened when it comes to brands. And I think there's even more pressure on marketing for any types of organizations, and I think you see it a lot in the nonprofit world, to be more dynamic with that, to kind of keep up with the fact that people do have short attention spans.
Did anybody read the article in the Washington Post this week on the Peace Corps? It was a front page article on the left-hand side, so I see some yeses out there. So I've read this story with a lot of interest. It really wasn't focused on the brand per se in terms of the trademark, but there was a statement in there, and I should have brought the exact quote, but it was something to the effect of the Peace Corps needs to, in effect, modernize its brand. And so that's something that nonprofits, just like for-profits, really are struggling with right now. Even if you're successful, you're trying to understand how to build brand interest and loyalty. And really what that means is you've got to be more dynamic in your branding and look for ways to constantly provide a fresh view of your organization to your, quote, consumer base. And yet do it in a way that obviously maintains the integrity of a brand and the integrity of your mission and organization. So with all that in mind, we have a new rule for you, and the new rule is that you may verb up strong brands, which, Justin, where did you hear that phrase first? Because you were the one who brought it to me. Right.
The term verb up is kind of interesting, taking a word, your brand, and turning it into a verb or an action word, but I'd say the person who popularized that the most, at least in the tech world when I was sort of directly in it, was the president and CEO at the time of Microsoft, Steve Ballmer. It was right around the time they were introducing the Bing search application or search tool, and he was really trying to push people in a heavy marketing spend to say, hey, I want people to Bing a restaurant or, Bing a vacation and things like that. Now, who knows in the end how well he was in terms of marketing. I think we all know, where he ended up. He's no longer the CEO. But that being said, I think verbing up was actually a very good way to talk about what you really want to do ultimately with your brand.
Yeah, great example. And so when we talk about more examples beyond Bing and, Binging a restaurant, things like that, Google, of course, I think has led in this area of breaking rules, and we're going to find that on this first rule that we're talking about breaking, also on the second one in a little while. But you'll see Google used and hear people use it as a verb, and I think everybody still understands that it's maintained integrity as a brand. And I was very interested to see about 6 months ago when we started thinking about this topic, or maybe 9 months ago, that Google, with respect to their Play Store for apps, online music and so forth, was starting to use a slogan that actually played, no pun intended, played on their brand, Google Play. So they used the slogan, play your heart out. And I immediately sent Justin an email. I said, take a look at this. They really believe in it. And so I don't know that they're using that campaign as aggressively today. I don't see it on top of their website, but they used it very aggressively with the launch of the service, and certainly filed trademark applications and so forth. So another good example that you came across, Justin, was vanguarding. When I did a Google search for this a couple days ago, we saw that they're actually using it pretty aggressively, as you see there. Right. So another good example, and they didn't want me to put this in the PowerPoint with the visual, but I'll give it to you in words. In the nonprofit context, everybody's going to be wondering as we go here, well, this is all well and good. It's academic. Google's doing it, but we don't have the resources, and it sounds like a high-risk venture. There are a lot of nonprofits trending in this direction, and why I can say that with some assurance is that I hear from clients on a more routine basis now with questions about doing things like this, and I'm observing rebranding campaigns that are different than they used to be. One that I always talk about is the rebranding from a client that we had that their acronym was kind of alphabet soup, and I think it was, I can't even pronounce it. I'm not going to try to pronounce it. It was like 5, either all vowels or all consonants. So They came to me one day a couple years, maybe 3 years ago, and they said, we're going to rebrand our organization as Leading Age. And my first reaction was, well, that doesn't make sense. That's a slogan. And it turned out to be one of the most successful rebrandings that we've seen. Jeff, do you have any thoughts on that?
Well, it's a lot better than their old name was ASHA, American Association of Homes and Services for the Aging. It's the trade association basically for nonprofit nursing homes, but they've had a lot of success with Leading Age in their new brand.
So Leading Age was great for them. It's not perfectly analogous to what we're talking about now, but it shows this trend happening, and they certainly were kind of toward the front end of it. The example I wanted to give was United Way. So if you go to their website, it says United Way very prominently, and then the slogan is Live United. Kind of like with Google, the slogan is playing off the name, and they're not afraid to take some risks in terms of the wording that they're using. This is a slide that Justin and I developed the theory for about a year ago, and is one of my favorites in terms of talking about trademarks because it really shows how you get to brand value. This is what every client wants, for-profit or nonprofit. We want a strong brand, a brand that has value. So what does that mean? How do we do it? How does everything we're talking about today fit into this context? So at the very bottom layer, you've got to have a brand that is distinctive. And so I'm going to step back and do some basics just for a minute, and then we'll get back into this. But who in the room has heard of the so-called hierarchy of distinctiveness or levels of distinctiveness for trademarks? Okay, another two people, same two people as before. The people who read the Washington Post. So in any event, this is like one of the basic concepts in trademark law and really essential to understanding how trademarks work. And I was telling Justin as we started that I regret that it has this kind of off-putting name, hierarchy of distinctiveness, because it just sounds like it's more complicated than it is. But essentially what it says is if you have a term that's generic, if you have, and that's the fear we were talking about with genericide, if you have a term that's what's called descriptive, it's not going to be immediately protectable as a trademark. Maybe a descriptive term could become a trademark, but essentially at those two lower levels, you're not going to have trademark rights to speak of. So if you draw a line there and you're climbing up a ladder, you've got 3 more rungs, which is where you want to be. Suggestive terms, and I'm going to go into examples in a minute. And a suggestive is something where it takes a moment of reflection to really understand what's being conveyed. Next up the level is something that's arbitrary, and that's a word that just has no relationship in the context of the goods and services, has no relationship to that context. And the highest level is fanciful. So, and that means made up or invented. So in the context of like for-profits, if we're working now from top to bottom on the ladder, you've got, Haagen-Dazs is made up. Not a lot of people know that. What a great brand. Down the level, you get an arbitrary term like Amazon. Well, that Amazon has nothing to do with, online sales. So, and it goes further down the line until you get down to the bottom and you've got like the word internet, and of course you can't protect that. In the nonprofit context, some examples working now back up the ladder are a generic term would be like nonprofit or association. Of course, nobody believes they can own that. It gets a little tougher as you move up the levels. Something that's descriptive and where you couldn't own rights immediately is like tennis industry association. And I apologize, I don't have a slide on the levels for this. But like tennis industry association would be descriptive, right? You can't really have trademark rights in it right away, but you use it over time and people come to know you. Then you have trademark rights. Where you really want to be to start, if possible, is above that line on one of the top 3 rungs. A suggestive name would be like Race for the Cure, right? It has 2 meanings, double entendre, so that's where you get that moment of reflection that qualifies it for immediate trademark protection. Higher up on the level, the equivalent of Amazon would be Mensa, which means table. So it's an arbitrary term in the context of the goods and services. And the highest level that would be the equivalent to like Haagen-Dazs would be Oxfam. So now that we've kind of set the table for no pun intended again, for distinctiveness, we're at this lower level, back to the PowerPoint slide, where we talk about you have to have distinctiveness. Okay, you're either going to have it immediately because you're on the top 3 rungs, or you're going to acquire it because you started out like the Tennis Industry Association.
And sorry to interrupt, but we should add that the vast majority of nonprofit trademarks, and I know you know this from our daily work, are descriptive. If you just look down our list of nonprofit clients, and you can, for almost every single one, you can tell what industry or profession or cause or issue they represent or advocate for. But as Andrew well knows, that doesn't mean that those names aren't protectable. In fact, in the tennis industry, we do represent the U.S. Tennis Association based out of New York, and that has certainly acquired a lot of distinctiveness over the years. So descriptive marks, while they are descriptive, and that tends to be the norm in the nonprofit world, are protectable over time.
That's right. Yeah, an excellent point. I don't want people going back thinking they have no trademark rights. But the risk, of course, is when you start as a nonprofit organization, and we're getting more and more nonprofit clients coming to us starting on the distinctive side. But if you start descriptive, well, you better be the only one in your field for a while if you're really going to develop those rights. And so, again, on this PowerPoint slide, you've got the distinctiveness. Is it available as a trademark? How available is it? Is it a crowded field of terms? Are you really the one who's going to own a really big penumbra of rights, big scope of rights? And are you exclusive in that field? So moving up and Justin, I'm going to have you take the top 2, but the next level up is brand registration and control. And so we'll probably touch on this very basic concept a couple times today, and that is that in trademarks, the registry is king. You've got to get your trademark registration. If you're sitting in this room and you work for an organization that doesn't know what it owns or doesn't have any trademark registrations, you really have to think about getting that protection, because in any dispute, that registration is always Exhibit A. So, of course, it's part of brand strength. Justin, what have we learned over the years about strength and value?
Right. So when we take a look at strength and value, the next 2 rungs on this sort of ladder of a list, and provided you've got a distinctive brand, provided it's available, you're using it exclusively and continuously, you've got it registered. Now we move into the level of brand strength. How strong is your brand vis-a-vis other competitors? How strong is it when you deal with consumers? That's very important to most of us lawyers as you think about that, because obviously that's the big question you always look at if there's ever a fight about your organization's brand name, or if there's ever a question about how some third party is using, or I'd better say misusing, your brand name. So your strength is really a measure of your ability to deal with those third party infringements or any misuse that you really would not agree with. And then last but not least, I think the holy grail of being able to really leverage a brand is when you look at value. And there are a lot of surveys out there, some that we see in the news every year and maybe don't pay much attention to, but there's a number of organizations who actually do go out and use mathematical algorithms to come up with a dollar value for what a particular brand may be worth in terms of money. And that's always, I think, for many organizations very educational, in a sense that whether you're a for-profit or a nonprofit organization, to really look at your brand as this living asset that really has value. And so the brands that are distinctive, that are registered and controllable, that you've monitored and kept third-party misuse down to a minimum, you often see those at the top of the list when you see these surveys in the business world, oftentimes for whose brands are worth X number of dollars. That's all directly attributable to this pyramid of strength that you've built up below that.
And so this pyramid of strength is important, because if you want to take advantage of breaking some of the rules, you really need to have a strong brand. And more nonprofits than one might imagine have strong brands. But this is really what, how to indicate, how to understand what a strong brand is, and if you have one. So now getting back to, breaking the rules, we've set out some guidelines that I think are helpful if you've decided, yes, you have a strong brand, yes, you want to take some steps in this direction of breaking those first 2 rules of the acid test. Justin, do you want to talk about the first one here, which is conveying to consumers what you're trying to do?
Right, absolutely. And so, with this bullet point, and you saw the example before with one of the sponsored links that we put into a slide with vanguarding, it's simply taking your brand and using it as an action word. Vanguarding. What is vanguarding? sort of the rule here, or at least the best practice we would give you, is to use that particular brand to reinforce the point that you want to convey to consumers. And you always want to have the policy of making sure that verbed up use is in direct connection to how you want your brand conveyed, and that it's not used separate and apart from the product or service that you actually do market to consumers.
And in fact, when you do what Google did, which is combine the Play Your Heart Out with Google Play, you're in effect telling consumers you can't play your heart out without Google Play. And so that's a great natural way to do it. On the next point, what you're going to want to do is publish guidelines as to how these verbed up brands can be used. And so you'll say, well, we refer to this as start vanguarding, but it's not yet vanguarded. And when we say publish, it may be publishing the guidelines internally or externally. Many organizations will have trademark policies, nonprofits as well, where you have the policies front and center on the website available for people to see. Kind of like getting your trademark registration, this type of activity almost creates a presumption that you're doing the right thing. If there's a dispute and people are saying, well, you're not really controlling this, you say, well, we're treating this as a brand, this verbed up version, and we have guidelines for their use. Another great example, we talked about registration in that brand strength pyramid, is to register your verbed up brand. And so, of course, Vanguard has sought to register the term vanguarding, and this is a very good example of the fact that they're seeking registration both for Vanguard but also vanguarding. And again, the registry is king.
Andrew, maybe it's a good place to just pause and kind of give everyone a couple-minute refresher on basic trademark rights, common law versus registration rights.
Excellent point. So in the U.S., unlike many foreign countries, you can have trademark rights based on your use of a trademark alone. Those rights are not nearly as good as the rights that you get through registration, but yet you have some rights. And generally, when those rights are evaluated, they're evaluated on a geographic area, based on the geographic scope of your use and sometimes the geographic scope of the reputation of use. And so that's kind of a flimsy place to be, in my experience, having done this every day for about 18 years. Because anytime you have a dispute and you say, well, we don't have a registration, but we really don't need one. We have common law rights. It always ends up into a matter of trying to prove it up. And in any organization, for-profit or non-profit, the records increasingly don't exist going back historically. And people would say, well, yeah, aren't there online records of trademark use like this thing called the Wayback Machine? Who in the room's heard of the Wayback Machine? Okay, good. Like maybe 20, 30%. That's not bad. That's a great record of what's happened on the internet, but it really doesn't cover every page of every website or all of, it may cover part of a page of a website. It may not cover, it may not go back in time fully. It's not really fully reliable. It's a good resource that we use whenever we can, but it's nothing to rely on. So if you have common law rights and you say, well, our organization's been around forever, how do you prove it? How do you prove the geographic scope of those rights? How do you prove the reputation? How do you prove that those rights really existed from 1997, like you said, on a nationwide basis? Wouldn't it be better if you had a piece of paper that gave you a presumption of those rights from the date that you filed a trademark application? And that's the power of a trademark registration. Because as soon as you get that registration, you have a presumption of nationwide rights from the date that you filed the application. And you'll make a statement in there as to the date that you first used the trademark, if you used it before you filed. But essentially, everyone's going to focus on that filing date. You'll be surprised, because time flies, how fast that registration will get some age to it and become increasingly valuable. It's a good time to kind of contrast the U.S. system and some of the Commonwealth country systems like the UK and Australia and U.S. with many of the other more challenging countries that Justin knows so well from the mobile industry, like China. Justin, will you talk about our favorite country?
Right. And I think this is actually a good point to mention that, because there are different schools of thought, and believe it or not, the U.S. is actually in the minority in the world in terms of how the trademark system works. Your rights start at really 2 points in the U.S., and I'd say the U.S., Canada, Australia is a really short list of countries that go this way. Rights either start with actual use, and this goes into the common law area, or they can start with the registration or filing of an application. The majority of the world, however, and China in particular, are first-to-file regimes where your trademark rights don't mean much. Even if you are using it, you have to actually file a trademark application in that jurisdiction, and from that date that they accept it, provided it's an appropriate and validly filed registration, your rights start. That's really important distinction because a lot of people, and naturally, all of us are in this category, lawyers or not. You start a business, you start a brand, you start an organization, you feel like you own that brand, you started it there. But if you take a look at what's happening in the global marketplace, you really only have that brand in the country that you have registered it for. And so that's why that's a very important concept.
And as Andrew well knows, because he works with me and with many of our nonprofit clients in this area, increasingly U.S.-based nonprofits are conducting activities and operating programs and providing services and doing other things overseas, and using their trademarks like their name, perhaps their certification marks, other marks overseas. And so what we've seen is a great uptick in the number of U.S.-based nonprofits that are registering their valuable trademarks overseas. For probably the client that we work with to the greatest extent in that area is a group called Project Management Institute. How many countries have we registered their certification marks in?
In fact, they're on the webinar, so I say hello to PMI. And I wish they were here in the room. They manage part of the portfolio in-house, but let's just suffice to say it's a large number of countries. And interestingly, PMI and others will tell you they have major problems in China. And setting aside PMI, another nonprofit, contacted us just in the last 24 hours and said, here are the Chinese characters that we think we want to use for our brand. Is it available? Is it distinctive? Can we register it? What's the strategy? That's a client that a year ago I would have said, no way would they care about China. So China should be on the radar of any nonprofit that has any kind of international vision, just by virtue of the population over there alone, but also because of the just great challenge of protecting intellectual property. And if you don't get in on the front end for, let's say, under $1,000 to file a trademark application, you can spend 100 times that dealing with it later.
Right. One quick point on that I'll bring up, because this is one interesting area in my practice that I see happen to all organizations, but I've seen, really, to follow up on what they've said, a big uptick on the fact that internationally, U.S. and European nonprofit associations are actually a target of certain entities who operate in China and other countries. The reason being is they know the trademark rules probably better than many of us, in the sense that whether you're a nonprofit or a business, that is a brand. And it's really sort of like the holy grail in the world of counterfeiting, the world of sort of criminal IP in many of these countries, to take a look and pay attention to, for instance, U.S. journalistic reports, U.S. business news, U.S. policy, things that are going on in D.C., so that they can game the system. What they particularly will do is, whether it's a celebrity, whether it's a business, whether it's a nonprofit that all of a sudden has become popular, there are groups of people, I'll call it even an industry unto itself, who specialize in taking your name, running off to the trademark registry in those particular countries, and registering it. And just to Andrew's point, imagine they're a year later as a nonprofit association saying, okay, finally we're at the point where we want to expand to China, and you're dealing with a situation where either your trademark in English or in Chinese characters has already been registered by someone that's not you. It's an expensive problem to solve.
Because remember, if another party has a registration in a first-to-file country, it means that they can stop you from using the brand in that country. That's the value of trademark rights, is the ability both to defend yourself but also to act offensively.
Andrew, we have a question from the webinar about timing of trademark registrations. Maybe first, if you could answer it, in the U.S., generally, how long does it take? And obviously, there's no hard and fast rules here, and different registrations can vary. But generally speaking, how long does it take from the time you file to the time you get final approval from the trademark office?
So in the U.S., you can get a registration in as fast as just under a year if everything goes well, and if you file based on proof of use up front. If you file on what's called an intent to use basis and you don't prove your use of your trademark until the bitter end, it can take up to 5 years. And that, by the way, has a significant impact on the cost. So if you're taking the 5-year approach, it will cost, it can cost easily, $6,000 or something to get a U.S. trademark registration. If you do it the fast way and you're proving use up front, In one class, it can be often for less than $2,000. So, acting early and efficiently in trademarks is, a great way to save money and get rights fast.
And generally speaking, if you can generalize, in foreign countries, how long does the process tend to take?
So in foreign countries, you can get it faster in some jurisdictions like the EU, where you can get it in a matter of months, and the EU covers 27 countries, or 28 maybe now, in one filing. There are other countries like Brazil that have been the slowest in the world and take 5 years. So you get extremes.
All right, and one more question. I know we're kind of bouncing around, but these are some basics that I think are worth covering. And you alluded to this earlier. Before we engage generally in any trademark registration here in the U.S. or overseas for our clients, we do trademark clearance. You do trademark clearance, you and your colleagues, and sometimes working with outside search firms. Can you just explain kind of the process and the principle behind kind of clearing a trademark and doing that kind of searching? And someone asked kind of what tools are available to do that as well.
It's a great point. Excuse my voice. So the standard of trademark infringement is really different than people expect. Everybody in the room is familiar with the criminal standard of beyond a reasonable doubt, which is the highest standard known to the law. I always like to say that the lowest standard known to the law is likelihood of confusion, which is the test of trademark infringement. Because if you do a survey of people in a shopping mall, which is a standard technique, if you have a trademark litigation and you're trying to establish whether or not there is a trademark infringement, if you get, say, roughly 20% confusion, you're going to feel like you've got a pretty good survey. And so that gives you an indication that likelihood of confusion really does not depend on all that much confusion. Well, how does confusion occur? The confusion can be dependent on similarity between the trademarks. If the trademarks are really, really similar, that can be one of the factors that can lead to it. Another is similarity in terms of the goods and services that are being sold, and another is the so-called channels of trade, or the ultimate end user or consumer, and how those goods or services are delivered to that party. Everything can kind of shift, and so if the goods and services are closer, the trademarks maybe don't need to be as similar. If the goods and services are further apart, but the trademarks are really similar, there could still be a problem. So that's a long way of saying when we do trademark searching, we are looking out for likelihood of confusion. We're trying to assess the risk that a client will face a challenge based on use in the marketplace. So is the mark available for use in the marketplace? And secondly, is it available for registration? And those are really two different assessments, and we often try to simplify and give kind of an overall risk level, but depending on the facts that are presented in a trademark search, we may explain that there's a risk with respect to registration that's higher or lower than the risk with respect to use. But all this is important so that you don't adopt a brand that's not available and where you will be literally vulnerable to a challenge of trademark infringement. So the resources that are available, we often do two types of trademark searching. Clients often, can go to the PTO registry themselves or get on Google and put in the term that they want and see if there's an exact hit. We don't really focus, of course, on that level of searching, but our preliminary level of searching is a fairly good look at the registry of the trademark office, and then we try to assess risk for use and registration based on that. At a next level of searching, which is very important if you're rebranding or if you have a new house mark, the next level is called a full search or a comprehensive search, and that's much more involved, can cost a few $1,000s or more to fully assess, based not only on the registry but also on those common law rights that are out there, right? The parties that are out there using brands but haven't tried to register them yet. That's what we're going to assess when we do a full search.
Principle you just alluded to, this kind of is raised by a questioner from the webinar, is that the same or similar marks can be used by different organizations, different entities, if they and they can coexist if they're describing different products or services. Trademark law only protects a name, a brand, a slogan, a logo, etc., for that particular class of products or services that it's used to identify. A trademark is an identifier of the source of a product or service. If they're different, significantly different products or services, those two brands can coexist, generally speaking, unless the mark becomes famous. I'm not telling you anything you don't know. In fact, you probably taught me all this stuff years ago. But someone has a question that there's a descriptive phrase they want to use for a learning tool that the nonprofit is developing. It's the name of a book title in a completely different field. They're not looking to register the mark, although perhaps they should. But she's asking, what are the risks? What are their rights to use that existing book title to describe a learning tool that they're developing?
Did you say that the book title's in a different field?
Yes, a different field. Well, let's presume that for the purpose of the question.
I'll try to answer it both ways just for fun. So if it's in a different field, I certainly wouldn't worry about it at all. If it's in the same field, you might not worry about it. This is an interesting topic that we were dealing with for another client earlier this week. Can you infringe somebody's rights in a book title? Well, the answer is generally no. You're not often going to have trademark rights in a title of a single work. Contrast that to a series, like the For Dummies series or something like that, all of a sudden you've got trademark rights. And that's the standard for registering a trademark for books at the trademark office is you have a kind of a series. And that's generally what you look to for books in terms of establishing trademark rights that might be infringed. The more interesting case sometimes is when you have trademark rights and someone else comes out with a book with the same title. And we've taken the position that despite First Amendment defenses and so forth, that there are cases where, yes, you can infringe somebody's trademark rights with your book title, even if it's the title of a single work. Justin, would you like to move on to the guidelines here?
Oh, wait, but one more question that just came in because it is relevant. As you said, the standard for trademark infringement is likelihood of confusion, or sometimes we refer to as confusingly similar marks. And obviously it's a very difficult term to describe and as kind of carry it out in practice. It's what people pay you a lot of money to help them analyze and whatnot. But the question is kind of how close can two marks be before they infringe each other, presuming they're describing the same general category of goods or services?
Well, how close two marks can be to each other really depends not on those two marks as much as on the landscape of third-party marks around there. So if there's a group, if the field is already fairly common with terms that are similar, then your mark can be fairly similar to the one that you want to coexist with. On the other hand, if there's really nobody else out there in the field, it's going to be harder for you to coexist with something that's very similar. But I caution that, it's really hard to have bright line, nice, easy rules in trademarks because it's so fact-specific, and you can take two different brands that maybe, just for sake of argument, have one letter difference, but the letter difference creates somehow a very dramatically different commercial impression. That can be enough to carry the day to avoid likelihood of confusion. It really just, classic lawyer answer, it just depends on the facts.
Okay, thanks.
Right. Okay, so moving forward here, we're going to put forth a few recommendations or guidelines in terms of how best to, if you want to take the step of verbing up or taking your brand and using it in the manner that we've talked about here today. So one first step, and these are actual steps that organizations actually have done and have worked, is to actually, once you figure out what your verbed up brand is going to be, send out letters to people in the publishing world or in media outlets that either in the way they're referring to your brand, either don't appreciate the fact that they need to connect, vanguarding with the action of someone investing, or Googling with searching for information on the Google platform, or examples of that. Another thing we recommend as well is working with the various dictionaries. Some of the terms that we've used even in the presentation today, I can just cite from memory even the Google dictionary entry, but they're actually in very recent editions of dictionaries entries for the word Googling. And that is a result of Google itself lobbying the various dictionary publishers to include definitions that describe the proper way to define what is meant by Googling, as opposed to just leaving that to the public or to the market to decide. Another thing that organizations should always do is just monitor how the public, monitor how your members, monitor how all of those who touch your association and its brand are using the brand and their view of it. Nowadays, because of some of the things we talked about in the beginning, it's a mobile world, it's a world focused on social media. There are great tools, looking at the internet, looking at Facebook, looking at Twitter to really see how people are interacting with your brand. And I think doing that regularly will give you an idea as to whether your brand is holding up in terms of its distinctiveness, in terms of how people are just relating to it in those various venues.
All right, so let's turn to the second part of the acid test, which I think is for all you visual people out there, the interesting part of the two. So the old rule is that you have to use trademarks in a consistent manner, and we believe you can break that, of course. The fear, remember before in using breaking the rule of using terms as adjectives, the fear was genericide. Here, the fear is that you're going to lose your trademark rights, but for a different reason, not because it becomes generic, but because you have these 2 or 3 or 4 or many different iterations of a trademark that can't be kind of attached or tacked together. That's the legal term of art. Cannot be tacked together to establish a coherent series of trademark rights that will allow you to continue your earliest rights forward. And so with that fear in mind, people are concerned and really want to avoid that, of course, as a scenario, and we agree with that. The times, though, are really changing for the same reasons that we set out earlier, and just to sum up, everyone's looking to build interest and loyalty. So with this new rule of using trademarks in a fluid or living manner, we look to, of course, Google and their doodles for the best example of what's happening. And this is an example, I think, that's really conditioned the world, because literally the world uses Google. So I would argue that consumers have been conditioned by virtue of Google's use of their trademark in this manner to really accept more in terms of brands, especially if a brand is well known. And so Google really is the model for how to do this. And we've got a couple examples there which are obvious to everyone who's seen them. A fluid trademark, that's what people have been calling trademarks like this that change, the Google Doodles. And we think that that's a misnomer. And this will get a little bit technical for you folks who are not really big trademark people, so I won't get too much into the weeds. But essentially, I think it's a misnomer because a fluid mark to me connotes a motion mark, and there's something called a motion mark that's a term of art within trademark offices, and that's when you have a mark with some fluidity, literally, or activity to it that has a beginning and an end. It's usually shown in a video form, and Justin and I, when he was in-house at Sony Mobile, then Sony Ericsson, had an example of this where there was some liquid flowing for a few seconds, and it flowed around the screen and then ultimately flowed into the client's logo. Well, that little video vignette from beginning to end created what's called a motion trademark, and something that you can register and protect. That's really different. That type of fluid or motion mark is really different from what we're talking about here today. I think that the better way to describe this type of term is as a living brand, something that kind of has growth to it or change to it, but the essential character of the brand is remaining intact. So let me talk about this next slide, and Justin, I'll get it back to you pretty soon. But this is a slide that I think was important for Jeff that we discuss, and that is to recognize, both for breaking this rule and breaking the first rule, that nonprofits are different, and I certainly understand that from the amount of time I've worked with nonprofits. And not everything that works for for-profits certainly works for nonprofits. And so this is a good moment to think about what is the tradition or culture or policy within your nonprofit organization. And is it appropriate within the context of that tradition, culture, and policy for you to, even entertain breaking these rules? Some considerations are, do you have members like many nonprofits do? Do you have chapters like many nonprofits do? And getting to the heart of it, how do you currently control the use of your brands by your members or chapters? Many nonprofits will say, well, Yeah, we have chapters and we have members, but our tradition and our culture and our policy says that all the chapters have to use the same logo. And then I go onto the websites of the chapters and they have different logos. And I go to the client and I say, well, they have different logos here. That seems different with your tradition, culture, and policy. And they often say, well, our policy is they can't do it. And I say, well, what do you do to enforce that? And I said, would you entertain breaking the acid test, in so many words? And they say, well, no, we don't want to do that because we don't want to lose our trademark rights. Okay, well, wouldn't it be better if you had a policy in place that really reflected the reality of what you're doing and made a credible case for how what you're doing is still consistent with trademark law? And so, I think it's very important then to think through, do your chapters, change the logo in some way to reflect the geographic region? You'll see uses of flags and things to augment a nonprofit logo. Or do they change their brand seasonally? I had a client complain, every time it's Halloween they put a skeleton next to the brand, and we don't like that. And I say, well, why? And they say, because not everybody's doing the same thing, and some are putting ghosts, and the whole thing's kind of ridiculous if you think about it. So essentially, we all know nobody follows the rules. The members follow the rules more than the chapters. How do we put it into place a credible story as to why we're allowing this change? Either you have to have a policy that allows for no change and enforce it, or have a policy that allows for some change and then you don't have to enforce it as much. Less work for you. So I think that sums up that slide list.
And we should just contrast this with, and I'm looking here at one of the articles we included in the handout materials that you had written, Andrew, a few years ago called Nonprofits Don't Get Caught Naked Licensing. And so we should contrast what you just described with a nonprofit that simply doesn't police the use of its mark by others. And we've seen that this article is about a case that involved a nonprofit that lost its trademark rights because it wasn't policing the use of those marks. Do you want to kind of speak to that for a second? It's something we see all the time in the nonprofit world.
Yeah, that's a good point. And there is a webinar, I think, from maybe last year where we spoke more at length on this particular subject, which is of great interest. And it's a challenging one for nonprofits because nonprofits used to think, well, we can do whatever we want, and the judges and decision makers will always cut us some slack because we're nonprofits. But those days are over, and there have been articles on the front page of the Wall Street Journal and other major publications that kind of reflect the changing culture of decision making when it comes to judging nonprofit brands. And so essentially, what this case decided was, just because you're a nonprofit doesn't mean you can get away with not following the rules of trademark licensing. Well, what are the rules of trademark licensing? If you allow another party to use your brand, you have to perform legitimate control over their use. And so what that means is you can't just sign a license, a document that says you're granting them rights and then put it in a drawer and walk away. You have to actually monitor what they're doing on some regular basis and make sure that not only the trademark's being used how you want it to be used, but the goods and services that are being provided by that entity are consistent with the quality level that you think consumers will come to expect when they see that brand. And so in this case, which was called Free Cycle, which had to do basically with putting your things that you no longer wanted within your home on the curb for other people to pick up and in effect reuse or recycle in a sense, use for themselves, or Free Cycle was the brand. This entity said, well, we're a nonprofit. Well, anyone who wants to use this brand can use it in any manner. And they lost their trademark rights because they just didn't control it. So when it comes to licensing, there are a few different things you should always do. And one is get a written trademark license because that's like the Trademark Registration. It gives you a presumption, in effect, that you're doing the right thing. And the next thing that you should do is actually do some policing, in effect, of your licensee and make sure that they're doing what you want them to do. What I like about strategy-wise is if you can do whatever you want to do, you can set whatever rules you want, you can set that the rule in the trademark license or the rule for your member or chapter, which is in effect through a trademark license as well, and I'll talk about that in a minute, but you can set for that rule to be that they can make certain changes to the logo, and that you're going to be in charge ultimately of whether those changes are acceptable, but you give them some latitude. And that's something everybody's afraid to do, but I think it can be done, and it's better to put it in writing and say we have a system and we're going to do it this way than not to turn a blind eye to it. So Jeff.
Yeah, and I should add that nonprofits, perhaps even more than for-profits, tend to provide licenses to their trademarks to a wide variety of licensees. You referred to members, you referred to chapters. We, of course, have certificates. We have entities that are accredited by the organization, so they're using the certification marks or the accreditation marks that are owned by the nonprofit, perhaps trade or professional association. There is endorsed service providers, where a membership association endorses a provider of certain products or services to its members and encourages them to purchase that product or service, and in exchange gets a percentage of the sales price as a royalty. There's consultants. There's joint venture partners. You might have a joint publication or trade show or conference or other things where your partner is utilizing a mark of yours, or perhaps is a jointly owned mark. In all of these cases and many more, it's critically important to have a written license agreement, either as part of a broader contract or a standalone license agreement, and Andrew works on many of these for our clients. And then, like Andrew said, to follow up and do that quality control and do that trademark policing to make sure those marks are being used in the right way.
An excellent point, and believe me, I don't want to do more licenses than I have to, so I'm always looking for opportunities where you don't need a license and for ways to just simplify the licensing process. So, for example, just as an aside, for many organizations that have what they will call certifications, what they really mean in the trademark world is that they have credentials or that they have an accreditation process, and that really the client usually is the one using the credential as a brand, and it's the member, or in many cases the credential holder, who's just using it as a credential and not really as a brand. In that scenario, there's no need for a trademark license. Also, when it comes to members and chapters, we're not really doing a trademark license in the normal sense where we go to everybody and we say, hey, you're a member, you're a chapter, we've got 10,000 of you, you all have to sign this thing. What we're doing is putting into place a 1 or 2 page part of the policy and making sure that the bylaws make that policy automatically binding on chapters and members, and that's the license.
There's a question in the back of the room there.
Yeah. We have a registered trademark for the name of our organization, but not for the logo. When we co-sponsor events or publications or workshops, etc., we allow other organizations to use our logo and our name in those materials for advertising and for publishing, etc., and even things that have been published, like reports, etc. Should our logo be trademarked as well? And then follow up to that, we also do this not only in the U.S., but in China, India, and some African countries where we have no trademark registration. Should we be worried about that?
Yeah, it's a great question. I'll take the first part, which is there's a no-brainer. Yes, the design, the logo should be registered. And in almost every case that we work with our clients on trademark registration, particularly when we start working with a new client or it's a new organization, we'll do separate registrations for the words alone and for the design, because you're protecting two different things. Someone could have use completely different words but have a similar design that's misleading to the public as to the source of those services. So it's critically important to register both in the U.S., and it's always very important to make sure you're registering them in the proper classes and that you're describing the services properly. That's another area that Andrew and I often find a lot of our clients have made mistakes in the past. You want to follow on?
I've got to get a great example that Justin and I have been joking about in the last couple weeks here. So I got a client call, or a prospective client call, last June or July, and it was a museum, a nonprofit, and they said, we have this new brand, we're going to do this $50 million rebranding and expansion of facilities, and And so we'd like to talk with you about maybe filing one trademark application. And I said, okay, I'd love to help you and hear my high-level thoughts. And I never heard back from them until a couple weeks ago. And they said, well, we saved $200. We filed with a sole practitioner in Austin, and now we've got this major problem because somebody else filed first. And I looked at the records, and the client didn't get around to filing until January, and they filed for the wrong stuff. So now they've spent already in about a week or two $10,000, $20,000 with us just trying to put the toothpaste back in the tube, and we're no way near to solving the problem. I mean, we've literally just done the analysis and laid the groundwork. So the registration is key, and I've just given you an extreme example, but it happens. Right. Justin, any other thoughts?
Right, and in that scenario you just laid out, I heard the international piece as well, and so generally I'd say yes, resoundingly, if your business, and it sounds like it is, or in the way your association is modeled, depends on international membership and international transaction of the reports and things like that, and if that's going to be part of the future, you certainly want to invest in trademark registrations, at least in, let's say, the top 2 or 3 countries outside of the U.S. that you do business in and that you project doing business in.
All right, so I'm going to race through the guidelines for using your trademark or brand in a fluid or living manner so that we can get to the copyright topic and have plenty of time for that. So if you buy into this argument, you should break the rules, and if you have a strong brand, follow these guidelines, and I think it'll serve you well. One, make sure that the design or stylization that you want to change is strong, that you have a lot of goodwill in it, and you can gauge how much to play with your logo by the relative strength of that mark. And I should just say as a very quick aside that nonprofits are doing this, and it sounds like something we're just proposing is this crazy idea, but I am working right now on a nonprofit rebranding, and it was not my idea, and they're going to do this. Literally, they're building this into their rebranding from the very beginning. So this is a real thing. Next, make sure to change only the design or stylization when you have these changes to your logo, not the corresponding word mark. So the word Google is always there, but they changed the design that's overlaid on top of it. Make sure the essence of the logo is retained. It's another way of saying the same thing, I guess. Continue regular use of the original design or stylization. So this is how the Google.com page looked the other day, and yet the page for Advanced Google had the creative design on it. Next, maintain trademark registrations for the original design because, again, the registry is king. And don't be a trademark bully. So the 30-second story here is, who's aware of the Eat More Kale case? Okay, excellent. About just a couple people, but at least somebody's heard of it. So Chick-fil-A sent a very harsh demand letter to a guy who was making T-shirts in his basement that said Eat More Kale. Chick-fil-A said, we own the brand Eat More Chicken. It didn't go over too well. Justin's really the social media expert between us, but from his time at Sony. But essentially what happened is this guy launched a basement social media campaign and got a lot of people behind him, and people really turned against Chick-fil-A for being a bully. I had, for a couple years, represented various clients against the Lance Armstrong Foundation, which, not saying anything people don't know, they were number 1 or so on the list of trademark bullies. So people keep lists of trademark bullies, in the blogosphere, and you don't want to be on that list, basically. And then, this is just my personal opinion that we should refer to fluid trademarks not as fluid trademarks because it's like a motion mark. It's really a living trademark. And then one more slide before we get to copyright, and this is I've gone too far here. And that is to advocate for trademark offices to give living trademarks special status. Now, this is like my long shot or dream goal here, which will be hard to achieve, but there's no harm in asking and trying to get people united behind me. But I think there should be a new category of trademarks that trademark offices respect that accounts for the fact that I've got this nonprofit client who wants to do what Google's doing, and there are other organizations out there all the time who are going to be making these changes to their brands. What happens to their registrations? Okay, they can register and keep the original one if they continue to use it, but how do we really reflect through the registration process what's happening? Are you going to file a new trademark application every day that you change your logo? In the nonprofit case, they have 6 different iterations that they're going to revolve through. And yeah, it's more feasible for them to register, but yeah, in the U.S. you can register them. What if you go to all their different foreign countries? That gets very expensive. So there's got to be a different way, and I think that the Trademark Office standard of alteration of a trademark is really too high to deal with this circumstance. What they say is if you have a material alteration to your brand in terms of your use, you're not going to be able to keep your registration alive unless you have some residual use of that original one. I think that standard's too high to deal with the current phenomenon. And so there should be some recognition that the underlying design or stylization is entitled to somehow somewhat broader protection, like when you've got a family of trademarks, and a family of word marks or trademarks is when you have one common root and you use other types of things around it. We represent T. Rowe Price, for example, and they have the brand Invest with Confidence, but they also have Retire with Confidence and Save with Confidence, and all these various with confidence-based marks. And therefore, they're building up more rights in with confidence. For a logo, I think there should be a similar type of treatment. I don't know precisely how it's going to get done, but that's my last 2 cents on breaking that rule. Justin?
Sure. So now for a clean break from trademarks, we're going to move into the copyright portion, which is admittedly a little shorter, and we'll conclude with this for the presentation, but continue with the same theme. With respect to copyrights today, we're not necessarily breaking the old rule, and the old rule in this context, like I started off in the intro, is that with copyrights, many of us, whether you're attorneys or not, know that when you write a book, when you paint a picture, create a piece of software, draw a doodle, your copyright begins at that very moment. From the moment of creation, from the moment it's fixed in a tangible medium is the actual sort of legalistic term. All that means is you've taken some work of art, some content, and put pen to paper. That, in essence, is all you have to do to have a colorable copyright in a particular work. When I use the term work today, that's synonymous with software. You can fill in the blank with the book, with the training manual, but something tangible in that sense. One other sort of copyright 101 thing here that I'll go into, because I think it's always important when you're talking about different forms of intellectual property in any sort of educational context. When we talk about copyrights, copyrights are really the vehicle of intellectual property that protects content. We've talked a lot today about trademarks. Trademarks are the vehicle of intellectual property that protects brands, slogans, the things which resonate with the consumer and lets them know that that's you behind it selling it. When we talk about copyrights, we're talking about content, music, training manuals, reports, all the various types of things that associations really in many cases find as their lifeblood and often find at the kernel or the source of an association's ability to generate revenue as well. It's very important, though, that given the history of copyrights, and it's something that I think people in sort of an intuitive sense understand that they have a right to what they create and that they should own that right whether or not they file a piece of paperwork to register it or not. I think all of us kind of intuitively have that within inside of us. What I can't overemphasize enough, however, is that all of us, and many of us, and when I say us, I include attorneys as well, kind of over-rely on the old rule that you have automatic copyright protection. You've heard a lot today the term that the registry is king or registering a trademark is king. It is no different in the world of copyrights. And I'll put it this way, this simply, particularly in today's modern world where we're on the internet and where you all are interfacing with your members, your constituents, and your chapters online and in the context of social media. You cannot enforce or defend your content or anything that you feel is proprietary content without actually having a copyright registration or at a minimum a pending copyright application on file before a third party is found to be infringing upon your rights. And that's going to be sort of the basic thing that we're talking about here for the rest of the day with respect to copyrights. What I'd like to get at, in essence, is that while the old rule is true, that you do have copyrights upon creation, you really can't get anything done, you can't enforce your copyrights, and particularly with social media platforms and ISPs, unless you have a registered copyright. That's super important when it comes to what we call the Digital Millennium Copyright Act. That's the latest in a long line of statutes to deal with copyrights. To make a long story short, I'll use the acronym DMCA, but that's what I'm referring to, Digital Millennium Copyright Act. Okay, great. Moving on to the next slide. When enforcing copyrights, the DMCA, in my opinion, in my experience in dealing with associations, the DMCA gives you really the most cost-effective, cheap, and often efficient way to deal with online infringements. It's a way that the statute is set up. It sets forth very specifically a certain procedure that a rights holder can use to notify a web host, an ISP, a social media platform to take down material that you believe is infringing of rights to content that may be there. This is important because prior to the DMCA, if you think about it, and many of you are involved in this in a legal context, whether you're lawyers or not, pre-DMCA, it's very expensive. If you think about the time it takes to pay, attorneys at a firm to draft up cease and desist letters, do research on what's happening, find the actual party who is uploading the infringing content, and then going into legal action against them before anything even happens on the web or before anything's taken down. It's very expensive and so much so cost prohibitive that not only were associations and nonprofit organizations not really able to defend their copyrights, but major for-profit companies as well. The DMCA was a bit of a compromise, if you will, between people who are rights holders and have rights in various content, and the people out there after the advent of the web who are the web hosts or ISPs, who, in a sense, and you guys have heard this argument before, are operating really as bulletin boards or allowing people to upload user-generated content. Why should you hold me as an ISP or social media platform, liable and as a victim for everything that every Tom, Dick, and Harry loads up on my site that could be infringing umpteen million different copyright owners out there and expose me to untold liability? So the DMCA, if you think about it, is a compromise between those who have copyrights and between those who are out there in the business of allowing for social media platforms or web platforms or for any sort of electronic bulletin board where content is uploaded.
And we should add that nonprofits in particular can and should take full advantage of this, because it's very common for nonprofits, not just associations, but all sorts of nonprofits, to have on their websites and other electronic forums the ability for members and donors and supporters and others to post content, user-generated content, and it's a very important tool for helping to protect the nonprofit from contributory copyright infringement for something that may be posted that does infringe someone else's copyright. And as an aside, I kind of view it as a corollary provision in a law called the Communications Decency Act of, I think, 1996. Section 230 actually provides similar immunity from defamation and other sorts of tort liability for, say, a nonprofit that's hosting a site where members or other users that are not employees or agents of the nonprofit are posting content that may defame someone else.
Right. That's a great point, and actually kind of reminds me of one thing. I always sort of look at what are the unintended consequences of various legislations and statutes, sort of who benefits from them after they're made. One point that I'll make just in my experience as an attorney in sort of the content and brand protection world is one of the groups out there who's most benefited from the enactment of the DMCA are actually nonprofits. If you think about it, having the DMCA offers and really made probably the most efficient tool and the most cost-effective tool that an organization can use, on the one hand, as Jeff talked about, to give you a really plausible way to reduce your liability if you're allowing lots of users or members to generate content and put it on your platform. But then on the other hand, it also gives you a very cheap and efficient way to go after people who are actually out there infringing, for instance, reports, training manuals, books, and software that you may be distributing as well. So the DMCA, I think, has particular use and is often underemphasized when it comes to the nonprofit world. So there's a lot of different reasons why DMCA and focusing on it is really important for nonprofits. In the upcoming slides, and I'm going to move through this kind of quick just in the interest of time without delving into each and every bullet. But the main point I want to get at here is that the DMCA does prescribe a certain procedure by which the content owner should go about notifying a particular site or entity that it's allowing infringing materials to be displayed. And then you have a certain procedure that's set in the statute that talks about how you should go through properly to file or send takedown letters. These slides go over some of the finer points, but the point of it is that you do have to put the particular, let's say, website on notice through one of these notification letters that infringing material is available on their site. Number two, you've got to define it, you've got to specify it and describe it such that they can find it and at least notify whoever that user or customer is that you believe that material or content that's being uploaded is infringing or not authorized in some way. You then have a certain amount of time where the ISP or host website then has to go back to that person who's uploaded the infringing material, notify them that you're upset about it, the content owners contacted us, this isn't authorized, we're going to take this down. That user or customer then has a certain amount of time to come back and say either nothing, which happens quite a bit because a lot of times people are kind of caught dead to rights. And so what I see oftentimes is about 70 to 80% of the time in my experience where we are working with a client of any type of organization and they avail themselves of the DMCA, about 70% of the time the person on the other end or the ISP complies, you never hear from them again, it's taken down in some short period of time, let's say a week on average, and there's nothing ever happens back. The other 30% is where it gets interesting, and that's what this goes into. Sometimes when you get the notification letters out, that person or entity who's uploaded the content may actually think that they have rights to it and disagree with you. They've got the ability to then file a counter notification or send a letter back basically arguing to that ISP saying, hey, we actually have rights to it. We came to get rights, through licensing through another entity, or we disagree. We don't think they even have copyright to protect this, or hey, we don't care what you say. I'm just still going to put it up. Come sue me. Something like that, where they're fighting back. And at that point, the ISP or web host has a certain amount of time within the statute, within about 14 days. I should say 14 days, that ISP will come back to you as the copyright owner. You then have about a 14-day time period to come back to them and basically say you're going to file suit against that infringer. That's important because if you come back within that particular time period, there's two things that really have to have happen. One, gets back to why registration is key. You've got to really be able to show at that point now, because we're down that 30% of people who are going to fight you or say that, hey, I don't care what you're saying, I want to keep that material up. That's where, one, it's important that at that point you want to be able to show either in your initial letter or in the follow-up letters that you have with the ISPA that, hey, we do have a registered copyright, and here's a copy of it. It's attached to our first letter, or here's a follow-up letter with a copy of our registration. And then number two, within that time period, once you do hear that the person is pushing back or wants to keep your content up that you disagree with, you've got about a 14-day time period in which to file a suit against that infringer. That's important because if they don't hear from you within that certain time period, that platform, that ISP, that web host is actually allowed, even during the pendency of the litigation that may ensue, to leave that material up. And then they won't face any liability for it. And they can just say, well, hey, you availed yourself of the EMCA, you can get back to us in time, we can still keep it up there. And until a court rules on this issue, because it's in dispute, we won't take it down. And so it's very important to make sure, again, can't overemphasize it enough, to make sure that you've registered the copyright. Sure.
The question is...
hold on, just wait for the mic if you could.
Great.
Thank you. The question deals with this time frame. If somebody claims that you're infringing on their rights and says, take down this content, and you say, fine, happy to take it down, do they still have a claim, a potential claim against you for the time period that it was up?
Yes. The web host wouldn't face liability, but yes, to the extent that rights owner could identify who that was who uploaded the content, absolutely, even for that short time, particularly if you can show, in a practical sense, some sort of damages. There was another, okay.
Just wait for the mic.
Recording or whatever. But the question that is, we're a trade association, and someone wrote an article for our newsletter. And we were mulling over the question as to whether or not it would be better to have people that law firm would like to share it with to either come and look at it on our website or give them something to put on their website that they could upload. Is there any advice you have on that, a thing that we should either be careful for or don't worry about?
Well, it depends. I mean, a lot, that kind of goes to one of the basic rules that if in doubt, ask and ask for permission. So in that particular scenario, if the rights owner is not the trade association and there's a separate person or entity who's the author of that article, the safest way always is to just go to that particular person or entity and say, hey, can we have permission to do that?
That was actually the person.
Okay.
Is it any advantage to the association that post it or like that themselves? Obviously, we're happy to share back and forth with each other.
Just repeat the question.
Yeah. So if you could repeat.
No, you summarize the question.
Okay. So, yeah, sure. Getting confused here. So in that scenario, if you've got another person who actually has written the article and you as a trade association are then asking the question, okay, do we host that material on our site or give it to another entity? One, I think it's probably best, particularly if you're already in good relations and in good communication with this person, one, to make sure you've, in a sense, formalized that permission. It may just be something as simple as an email to say, okay, we just want to be clear here. Do we have a right to post this on our site? We want to use it in the following manner. You can have a communication just that simple in an email or in writing, and then that, voila, is, in essence, it's simple, but that's your license or permission to do so.
And I should add, as an aside, and there's a lot of kind of copyright basics that we could cover here. Unfortunately, I don't have time. But in the nonprofit world, first off, what Justin just described, most folks, most copyright owners tend to be more willing to provide that permission, that license to a nonprofit, say, than to a for-profit.
That's right.
Most of the time, if you ask for the permission and you make clear your limited use you're going to make of it, you'll get that permission.
Right.
It's always safer if you're not sure to ask. But the other thing to keep in mind is nonprofits are heavily dependent on the copyrightable contributions of volunteers, of members and volunteers and others who write articles and give speeches and create other valuable copyrightable content for the nonprofit organization. But unless those folks are employed by the organization, where the copyright assignment happens automatically by virtue of law, where the assignment goes from the employee to the employer if the work is within the scope of employment, for non-employees, members, even paid contractors, vendors, consultants, the copyright is going to vest in them unless it's transferred over to you, either assigned, which is a complete transfer of ownership, or a license, which is permission to use. So it's a very important practice, and it's certainly become a best practice in the nonprofit world, to have those who are giving copyrightable content to the nonprofit to either sign some sort of an assignment, agree to a simple transfer of ownership, or to provide a license. And those things, for an assignment to be valid, it has to be in writing. A license doesn't necessarily have to, but it's a best practice to do so. Right. We're about out of time. Why don't you finish up the last slide, Justin?
Yeah. Well, we're going to finish up here, and we can always take questions offline as well. But just 2 quick points here to finish up on the presentation. Obviously, these slides, from what I understand, will be made available, and I want to sum up really just 2 quick points. One, we've already talked about the situation today of how do you best enact your rights under the DMCA, how important it is to have a copyright, even though you do have rights to a work without registering, but to make sure that you have registered it. One of the other biggest reasons why you do want to go through the steps of registering copyrights is when you do end up in those scenarios where a third party is infringing upon your rights or you want to stop someone from doing that, if you have not registered prior to the time you're filing suit, and it depends in different jurisdictions how this goes, in almost all cases you'll not be able to get damages. You'll not be able to avail yourselves of a number of the different benefits that the copyright statute allows you to have if you actually have a registered copyright and you put people on notice before you actually file suit against an infringer. Last but not least, and the one other point I want to make, is that separate and apart from the action of registering, filing a copyright application with the U.S. Copyright Office, there's something else called recordation. And this is important for associations, nonprofits, and really any organizations that have, let's say, books or software that you actually may be importing into the U.S. or having made in one place and shipped to another or being shipped around internationally. Separate from registration, you can actually take a registration that you have in a copyright for a work and actually file it with the U.S. Customs Office, and it's called a recordal. A recordal is a nice way of saying just registering an IP right with the Customs Office. Why that's important in one quick short sentence is that now you enable the customs office to actually help you, almost as a force multiplier, and actually enforce your rights to that particular work in situations where third parties may be importing or distributing, let's say, your software or your book or your training manual, artwork, or whatever it is without your authorization. So in sum, two quick things here. Although you have copyrights in a work from the very beginning, one, you must always want to register it to be able to protect it. And then two, to the extent that your nonprofit is interacting with tangible goods, whether that's books, software, training manuals, those are some of the most common examples I see, it's always worthwhile to look and see if you want to actually record rights in your copyright with the customs office. And that, in conclusion, is what we have.
And Justin, one quick question for you. We know that trademark registration with the U.S. Patent and Trademark Office and overseas, unfortunately, is not inexpensive. Right. Both the fees that the USPTO charges, Patent and Trademark Office, as well as legal fees, it's very difficult to do trademark registrations without trademark counsel. In the copyright area, though, by contrast, thankfully that's not the case. You want to speak 30 seconds on that?
Absolutely, and compare and contrast with the cost, just filing costs alone. So in the U.S., to do an e-filing of one copyright for a work, the filing fee is $30, very inexpensive. And it's actually not a really complex set of paperwork that needs to be filed. It's something that most organizations can be taught to do very quickly. Number two, the recordation piece that I talked about, if you wanted to go a step further and take a registered copyright that you had in the work, get it filed with customs and try to enlist them in helping you to protect against counterfeits or protect against some other entity who's distributing your books, the filing fee for recordation with the U.S. Customs Office is $190 per work or per right. So again, in balance, for a $30 filing fee for a U.S. copyright, $190 for a U.S. Customs, those pale in comparison to the situations that Andrew and I and others have dealt with where you're spending tens, hundreds of thousands of dollars to try to sort of unscrew something a year later.
And for nonprofit organizations, your intellectual property is oftentimes one of your greatest assets.
That's right. Along
with, say, your employees and your money in the bank and your investment accounts. Beyond that, most nonprofits don't have great inventory and other things that are valuable assets like a for-profit company does. So if your IP, your copyrights and trademarks in particular, are your most valuable assets, right, you'd be crazy not to do everything you can to give this full protection. Right. All right, I want to apologize for the out of time. We'll stick around here up here in the room in D.C. for those of you who have questions, and feel free to contact any of us online. Our contact information is on this slide. We also have links there to our online library of 800-plus articles and presentations on a wide variety of legal topics, as well as a link to our nonprofit YouTube channel with all of our recorded webinars. Thank you, Andrew and Justin, for a terrific presentation. Thank you all for participating, and we hope to see you back here next month. Thank you.